Hidden risk of non-immigrant visas. Can they affect your green card?
Hello, greetings. I am Attorney Edwin Fogam. I have practiced immigration and other areas of the law in the United States for the past 28 years. Let us look at a hidden risk today. What is this hidden risk? It is the hidden risk of how your application for a non-immigrant visa or the non-immigrant visa itself can affect your application for a green card. There are two ways that this can happen. The first is the information you provide when you obtain a non-immigrant visa like F1, B1, B2, J1 can subsequently be used against you if they misrepresent or they were not correct. That is when you are applying for a permanent residency. And this can rise to the level of misrepresentation or fraud, which will make you inadmissible. That is, you cannot obtain a green card. So you have to watch out for that. The second is what is called immigrant intent. There are some visas that have dual intent and others do not. What do I mean by that? Generally, when you are obtaining your non-immigrant visa, the intention is that you're coming to the United States to return. So it is a temporary visa. And if at that time you don't indicate an intention to stay permanently in the United States, but upon entering the United States, you apply for a green card immediately, that can be considered fraud. If your visa was a non-dual intent visa, which is visas like F1, B1, B2, J visas. Now, if your visa was a dual intent visa, in other words, even though it is a temporary visa, you are permitted by virtue of the law that is granting you that visa to subsequently obtain permanent residency in the United States. You are not obliged to rely on the temporariness of the visa. That is what dual intent means. So you have to make sure that if your visa is not a dual intent visa, the way you proceed to apply for your green card in the United States, you have to do that very carefully. There is the 90-day rule, which again is a flexible rule that is applied by USCIS. If and when you enter the United States and you subsequently apply for permanent residency within 90 days, for example, if you come in with the B1, B2 and you get married within less than 90 days, the presumption is that you are somehow violating your non-immigrant intent. It is a rebuttable presumption, but it is there. So it is important to consider or to know about these two possibilities, these two risks that can affect how you apply for your green card upon entering the United States. I hope this information was important or helpful to you. If you would like to know more or you have any questions, please feel free to contact us. Our phone number is 301-608-1555, and you can send us an email to info@fogamlaw.com. And as always, don't forget, don't fear the system, understand it, work with it, and benefit from it. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.